Again until like the other day. I was like, oh my God, it's on there again.
Okay. Great. Well, good evening, everybody. Why don't we start? So we're here for the for our public meeting of the Danvers Planning Board. So it's January 14th, 2025. It's a little bit past 7 o'clock in the evening. We're here at the Danvers Senior Center. I'm Louis George. I'm the chair, and joined here today by Jean Hartnett, our clerk, Jim Sears, Tim Spittle, and Michael DeCoulis. And Josh Morris is here from town staff. Okay, let's begin with our agenda here. So our first agenda item is Trask Lane, partial release of covenant. So this is a request for partial release of a covenant established on August 28th, 1972, which is associated with the definitive subdivision plan entitled Proposed Access to Folly Hill Development, Danvers, Massachusetts, and dated June 2nd, 1972, and also known as Trask Lane, Danvers, Mass. I see the applicant is here, and before we begin, I just wanted to mention this is a continuation from a meeting, from a previous planning board meeting. And so we'll be doing today is I'd like to hear from the applicant. We also do have our town council here today, who will be presenting and will be taking questions from the board. In addition, although this is not a public hearing, if we do have members of the public who do have questions specifically related to the covenants involved here, I'll also be entertaining some questions from members of the public as well. So with that being said, why don't you begin and just identify yourself for the record and for those watching at home.
Good evening. Thank you, Mr. Chair. My name is Miranda Samasco. I'm with Glovsky & Glovsky in Beverly, and I represent Corcoran Trask Lane LLC, the applicant for this matter. We have a couple of members that are also joining remotely. So we
Identify themselves, that would be great.
Sorry?
If you could identify them, that would be
Yes.
great, please. Thank you.
So on behalf of the applicant, we have Tim Corcoran and Peter Mahoney. We also have their traffic consultant, Rebecca Brown from Greenman Peterson, and counsel Dan Bailey from Pierce Atwood. And I'm joined by Emily Pothier, who's a colleague of mine at Glovsky as well. So I just thought it would be helpful to recap briefly where this started and where it sits right now. We were here before the board in November to present the formal request for the partial release of the covenant from 1972. We did a brief presentation on sort of what the project entailed, and in particular what it entailed in Danvers, and we reviewed a potential peer review scope that was sort of forecast by the covenant. Following the meeting, that we sort of had not agreed on a scope. There was some tension about how wide that scope would be, and in the intervening period, there was some discussion with staff. And then there was an exchange of legal memoranda between Corcoran's counsel and town council, which culminated in a December 18th memo from the town's council that was shared with us, agreeing with our analysis that the covenant is not enforceable because it has extended its enforceable life, and I will let the other lawyers talk more about what that argument is. But the headline is that I think that the town's council at least agreed with the analysis presented by Corcoran's lawyers at Pierce Atwood. So the applicant went on to say that, we would still like to work cooperatively with the board to help do some review of the traffic impacts in Danvers, provided that the scope was appropriately limited to those ways actually within the board's jurisdiction. And so we've had some back and forth in the meantime, and we have proposed formally that the scope be reduced to 2 intersections off of exit 44, being the intersections of Trask Lane and Wayside Drive, and the intersection of Trask Lane and Folly Hill Drive. And just to maybe elaborate on the thinking behind that, first of all, any of the other roadway intersections that were identified and studied in the applicant's traffic assessment fall within the jurisdiction of Mass DOT. And so all of those intersections will be studied by Mass DOT, they will be approved by Mass DOT, and they will be really a priority during the traffic review of the MEPA process. So we're not turning a blind eye by any stretch on the implications for those intersections, but rather saying that there is already significant state process in place to review those impacts. So I think from the applicant's standpoint, and I know the board probably has questions and comments as well, but from the applicant's standpoint, where we stand tonight is hoping to come out with an agreement as to this reduced scope so that we can proceed to get that work done, whether it be by a third-party reviewer or by the town engineering department. I think we can have a discussion about that, but that's what we are hoping to achieve tonight.
Sounds good. Just a question, in terms of your intro, and thanks for the recap on this. In terms of, if you can just more for the, also for those who may have missed this the first time around, the relevant parts of the covenant, I believe, is at paragraphs 13 and 14. Was that right?
That is correct. Yes.
Just who they relate to?
So the covenant, what the covenant said in 1972 was that if the number of units in Beverly served by Trask Lane exceed 554, that the applicant would come back to the planning board, and the planning board would have an opportunity to review traffic impacts on ways within its jurisdiction, purely with respect to the safety of those ways. And so that was what precipitated our first trip here to the board.
Do you have anything further from any of?
I don't think so. I'm happy to ask questions, to answer questions, and we have folks here from the team available to answer questions. But I think at this point, I imagine the board would like to hear from town council, and we can take it from there.
Members of the board, do you have any questions before we move on to town council?
I have a lot of questions, but we can wait till the town council.
Okay. Okay. Why don't we ask town council then to come to the podium, introduce yourself, and give a.
I have copies of the executive summary. I'm not sure if that has gone around.
Okay.
Sorry, let me just pass that down.
That's good.
Executive summary, okay. Thank you. Thanks.
Okay, my name is Etty Singer. I'm here on behalf of Dave DeLuca, Town Council.
So I'm going to start by reading into the record the executive summary that I just gave you, and then I can answer any questions about the initial memo that was sent on December 18th, anything in general. Okay, is the mic okay? Very uncomfortable with the mic. Okay, so the Trask Covenant established in, I'm calling the Trask Covenant the covenant that we're referring to, established in 1972, is a restrictive agreement between the town of Danvers and HD.
I'm sorry, could you speak up a little bit and a little
Okay,
more
we'll
slowly?
do the mic again.
Thank you.
Okay, so it's the Trask Covenant established in 1972 is a restrictive agreement between the town of Danvers and HDC Incorporated. Under Mass law, such restrictive covenants generally expire after 30 years unless specific actions are taken to extend them. In this case, no such extensions were recorded, meaning the covenant likely expired in 2002. Massachusetts law places a strict time limit on land use restrictions with limited exceptions. Although the Trask Covenant has likely expired, the board may wish to reserve the right to evaluate whether any avenues for enforceability exist. However, the likelihood of successfully pursuing enforcement through these exceptions remains speculative. Even if the covenant were still enforceable, its provisions restrict the board's authority primarily to addressing traffic safety concerns in paragraph 13 and 14, as we just discussed. In conclusion, the Trask Covenant has likely expired. Nonetheless, the board can investigate potential avenues for enforcement if they wish to preserve the covenant's original intent. By the last sentence, I just want to reiterate that 99% of the door has probably closed. There's probably like a 1% chance that to get any kind of enforceability of the covenant, which would be traffic, paragraph 13 or 14. But like Dave always says, you can't look in a crystal ball and know exactly, so that's where we stand at this point.
Thank you. Okay, having heard that, I guess I'll turn things over to the members of the board for questions. Why don't I begin with Jim?
So just in plain English, just for the members of the audience, the neighbors, and for the members of the board, as far as the covenant, do we want the covenant or do we not want the covenant? It seems that if we do want the covenant, it gives us some input. If the covenant is not enforceable and has expired, then what is our purview?
So if the covenant was still relevant, was not expired, the only power that it really gives the board is the traffic safety.
Yep.
Because the rest of it is not relevant. So if it expired, which it likely did, that means the traffic safety wouldn't be in the purview of the planning board. If the applicant is willing to agree to do that, to work with the board, that could limit the scope, but it could give you some scope to be able to do the traffic safety study.
So I guess to push the issue, if we say we need peer review and the applicant says, we don't believe you need it, because we've limited the scope of that to just the two roadways, are we at an impasse, or do we not have authority to require the additional review?
I wouldn't say you don't have authority. I think there's still, there might be some room, and there also might be just some agreeable to just agree to do that. That would probably be the easiest thing.
Okay.
Yeah, I wouldn't say that you have no authority at all.
And then to take it even a step further, would the board, be able to say, we don't like this project and we don't agree to it because we think there's too much traffic or impact on the town?
I think that's a reach. Yeah.
I guess it's good to hear from town council as to what our limits and the scope of
Yeah.
our actions are this evening and at perhaps a further meeting. So it would be difficult for us to say, what you're saying is it'd be difficult for us to say, no, we don't like this because it's too many units, it's overburdening the roadway, it's not really, a development in Beverly is not really assisting the town in any way.
Right.
Granted, we don't use our water or our schools, but it's going to burden our roadways.
Right.
Additionally, this one particular roadway where there are alternatives that the applicant could use in Beverly, albeit 62 or through the golf course.
Right.
but they haven't explored those.
Yeah, but regarding the project in general, there's nothing in the covenant that would have given, even if it was still active, would have given the board the ability to have a say over that. Unfortunately, it was very limited to the traffic safety, that's all it gave the board.
So if we ignore the covenant, then are we saying she doesn't even have to be here?
I'm sorry, what was the last thing?
Are we saying that the applicant doesn't even have to be here if we ignore the covenant and say the covenant's expired? Does she even have to come to this meeting?
Well, it's a good question. I don't have a perfect answer to that, but I do think because the intersections and it does burden Denver's traffic, I think it is appropriate to be before this board.
Well, if I'm building a warehouse in Topsfield, do I need to, on the line, the Danvers line, do I have to go to a Danvers board? I wouldn't think they would need to even be here if it's expired.
But the thing is that we are talking about those intersections that will be burdened. So do they need to be here? I don't know the answer to that, honestly.
Yeah.
But it sounds like the appropriate thing to be here.
No, I'm glad they are, but I mean, if you're telling them that the thing's expired, then what's our jurisdiction?
I don't have an answer to that right there, but I think that, I think we are at the point where the conversation is already going about, what are we going to do about the traffic safety? So I think we're at a good point with that. I mean, the applicant is here to talk about it, so I guess we take it from there.
Okay. That's all I have at the moment. Thank you.
Thank you. Tim, questions?
Yeah, maybe one question for town council before we move back to the applicant. In the memo from town council, I didn't see any mention of the jurisdiction with respect to which intersections and the geography that is covered by the covenant. Is that something you've opined on?
No, because the covenant itself didn't speak about specific intersections, and we only did a study of the covenant itself and the mass regulations.
Okay, thanks. Nothing else for town council.
Okay. Dean, questions for town council?
No, I think you answered everything I was wondering. Thanks.
Mike, questions for town council?
None for town council, thanks.
I just have a few questions for town council, and I guess this comes down, just picking up, I guess the question is in terms of the intersections, and I'm taking a look at I'm just taking a look at the language of the covenant. Now, again, and I know you stated that the covenant likely expired, but in the event that it is not, then the language, I'm just, looking at the language of the covenant in particular, I'm looking at 13, paragraph 13, that it says, that at the time, HDC will not construct more than 554 multifamily dwelling units without the prior approval of the town's planning board. The approval of the town's planning board will be restricted to consideration of traffic safety on ways within its jurisdiction. So does that mean, I guess the question, does that, again, looking sort of at the scope of what the, in terms of even looking at the traffic safety, and in terms of, are we looking at the, are we looking at the area of, are we looking at the intersections of, of Trask Lane and Wayside, or Trask Lane and Folly Hill Drive? Or can it, because I know at our last meeting, we talked about even a sort of a broader scope to other intersections that weren't directly at that area. Would that covenant provide?
From reading the plain language of the covenant, I think it would. I'm not familiar with the names of the cross intersections, so I'm assuming anything within the Danvers jurisdiction, it would allow for traffic safety on that. I don't think it's restricted to any specific intersection. I don't believe so.
Okay. Got it. Okay, that's the language. Yeah, they're just passing me the language here from the covenant.
Lou, I actually do have a question.
Yeah, go ahead, Mike.
So, when you say it's limited to the traffic safety, I think is the words you use, the verbiage you use, traffic safety.
That's the covenant.
Yeah,
verbiage.
so the traffic safety, what does that actually mean, though? Because if, let's say the covenant was not expired, they came to the board said, we feel this is going to be unsafe to have all these cars on this road. Would they then have to find a safer way to get the cars out of that? Would they have to not do the project? Like what, if the covenant was not expired and we said, we don't feel it's safe, because that's the only jurisdiction we have is the traffic safety.
Right.
What would the next steps be?
So the next steps, I believe, are in paragraph 14, where, I'm just going to read from the memo that I wrote, that they would agree to try, that the HDC, which would be the applicant, and the town would agree to hire a traffic consultant to evaluate the project, and then it would be reviewed and finalized by the, the relevant sections would be reviewed by the Mass Department of Public Works. So I think it would be, I don't believe from the covenant language, it means that they wouldn't be able to use those intersections. I think there would be a study to see on its effects, and I guess work from there of how to make it safer. I'm not exactly sure of that.
So even at worst case, they're just going to review those intersections, which it sounds like they're agreeing to do anyway. Am I understanding that correctly, or am I missing something?
Should ask the applicant that, I'm not sure what they agreed to do.
Could the applicant come to the podium and just say which one? That'd be great, thank you.
So the applicant has agreed to review two of the intersections that are Danvers Public Ways accessed off of exit 44. Those are ways within jurisdiction of the town. Just so board members are aware, what's proposed there as part of the project are some modest striping and signage improvements to make it more clear for residents coming to and from the property. So we're talking really a pretty light hand of improvements. So, that we have agreed to do that. The applicant's trying to be cooperative. We are trying to work with the town, given the changing information that both you and we have regarding the enforceability of the covenant. I think if we had had these opinions to start with, we probably would not have set down this road, because the improvements within the town's jurisdiction, again, are really quite limited. They would not, in and of themselves, trigger any planning board jurisdiction. They might trigger, a review with the engineering department or public works to make sure that the signage regulations were complied with. But had we had the opinions that you have before you now, we would not be here.
Just a question, Mike, did you have
I have another question. I guess, just to clarify, if everyone agrees, it sounds like we're saying that even if we disagreed with this and the covenant was still intact, all we would be getting is the traffic study, which is what we're still getting now. Is that a fair statement for someone to agree with?
Yeah, I don't want to, that's up to you to decide, but it's.
Why don't you speak at the microphone?
From the language of the covenant, it would be extremely limited, the planning board's jurisdiction over this, and it would only be traffic safety. And paragraph 14, I just was finishing to read that, it does say that if there was, anything had to be changed, there would be traffic control devices would be installed at the expense of the applicant. It is a very, it's not giving a lot of discretion to the board.
Okay. And then in addition to that, I forget what the number was, 554 or something like that?
Yeah, that's in the covenant.
Now that the covenant's expired, does that mean they can then continue to build more units in the future, and that there's no more
That's beyond the
review?
scope of this.
I can take that.
Yeah, yeah.
I think that would be governed by the zoning in Beverly, independent of the
But
covenant
this board would
here.
still have no review process over adding 300 more units if Beverly was okay with it?
Correct.
Okay.
Just a question I had, just in terms of talking about, and I know that, town council was just making a point about the limited scope, and I know that that Mike was mentioning about that the applicant is, at least has agreed to be looking at a peer review of those two particular intersections, for lack of a better word, but also it's been during the course of your traffic study, you did cover, other intersections in Danvers. And so that's why I think at the last meeting, I don't think we pulled some of these, I don't think these numbers, these other intersections came out, arbitrarily. I mean, I think that was from the study. So how does that, and this is, I guess, a question for the applicant, how does what you've reviewed in the traffic study, how does that sort of inform what a peer review should be?
I'm going to take a stab at it, and if, Rebecca, if I go astray, can you jump in? But
Absolutely.
the reason that the more extensive body of intersections was included was a result of both the City of Beverly's desired scope in its traffic review, as well as anticipating what would be required for MIPA. And those intersections are all, I think this is where I need you to check me, they are DOT intersections because they directly relate to the interchanges, I believe.
That is correct, yeah. So all of the intersections along Elliott Street that we were previously looking at, those are all within Mass DOT's jurisdiction, as well as all the ramps to and from Route 128. So the only two locations that we're really talking about are the Trask Lane and Wayside Drive intersections where the highway ramps meet those roadways.
And just for the record again, could you identify yourself again, just for the...
Yes, sure. I'm Rebecca Brown from Greenman Peterson, and we're the traffic consultants for the project.
Okay, thank you. Okay. Any questions from the, I know that we have the applicant here, and we've had town council speak. Any further questions?
If I could just jump right in on that question, what about the Conant Street State Road intersections? Are those within DOTs? Those were in the traffic study, but...
Yeah, so we had in the traffic study the intersections of Conant Street, State Road, Burley Street, Liberty Street, where those kind of come together in a triangle. Those we were asked to look at by the City of Beverly, even though they're not in the City of Beverly itself. But when we did go through the traffic study and looked at that, those intersections, what we found was that there really wasn't a reason why traffic to and from the site would be going through there. So it's not a direct route for anyone getting to or from the site from any of the major roadways that they would be traveling from. And that information was all just recently reviewed by the City of Beverly's peer review consultant, and they agreed with the distribution that we had assumed for how traffic would get to and from the site. So based on that information, we wouldn't have any impact on those three intersections anymore.
Understood. If I may, I wanted to go through a handful of questions because we haven't seen one comprehensive presentation here, so I'm sort of piecing together a few different memos from all of you. If you don't mind if I just go through them and ask a few questions. So
Sure.
We had an original memo before our first meeting from you, Attorney Samasco, dated September 4th. We had a follow-up memo from Attorneys Bailey and Heyer, December 2nd, which was the bulk of the sort of content of your response, and then an additional memo today, January 13th. So I'll just sort of, from you, Attorney Samasco. So if I can
Yes.
go through those quickly. So I have most of my questions are for the memo from Attorney Bailey, so maybe I can direct them towards him. So let me read some quotes here from the memo. First one being, quote, at that meeting, being our November 12th meeting, the board expressed that it had broad authority to disapprove the project, quote, and or require mitigation outside the areas of board jurisdiction. If I can also read a quote from the meeting minutes from that, Board Member Sears asked, do we have the ability to deny the project essentially based on traffic? Staff member Brian Zacchelli said, you may request to have legal counsel available. We all agreed yes. So is there a reason, Attorney Bailey, why you misstated that we expressed that we had the authority to disapprove the project? Because it seems pretty clear that we were asking for town council to weigh in on our jurisdiction.
not sure I understand the question.
Well, you said in quotes that we expressed that we had the broad authority to disapprove the project. The word disapprove did not show up in the meeting minutes. We very
Well, my
explicitly
recollect-
asked for town council to weigh in on our authority. So it seems like that's a misstatement or a mischaracterization of the record.
Well, I don't agree with that. My recollection of that hearing is that this board quite clearly expressed some intention and asked staff whether under this covenant it had the ability to not approve this project. And our response to that, as stated in our memo to town council, is that the board does not, for the reasons stated in that memo and confirmed by town council in its memo.
Right, but as of the November 12th meeting, so from your original memo, Attorney Samasco, quote, "There are a handful of conditions in the covenant which on their face have continuing force," right? So as of that meeting, we thought the covenant still had force. We have since learned, and you said, quote, in your memo, Attorney Bailey, this approach, being our alleged expressed broad authority to disapprove, compelled us to revisit the scope of the board's authority, where you then realized that it had expired. So my point being that as of that meeting, we all thought it was still active. Now we know it's not. Our pushback there was not that we thought we had broad authority to disapprove the project, but that we were communicating some skepticism about the traffic that was being pushed, and asked very explicitly for town council to weigh in on what our authority was. That may seem like a small thing to call out in question, but it's quite frustrating to see a mischaracterization of what this board had expressed as what we thought our authority was. So my next question is,
Can I jump in and respond to that, please?
by all means.
First of all, I don't at all appreciate characterizing anything as mischaracterization. As you have heard from my client and from Attorney Samasco, we're here to try to be cooperative. It would have been much easier to take the approach that this is unenforceable and we don't have to talk to this board at all. Instead, my client chose to come to this board and have a discussion about a covenant that we all knew was very old and of questionable durability. This board then took a very aggressive position that included raising the question of whether it could deny the project outright, even though the materials we had submitted had been extremely clear about the board's limited authority to address traffic safety concerns within your jurisdiction. The board overstepped those boundaries. That's when we said, okay, we have to revisit this. We wrote the memo we did, we sent it to your town council, and your town council agreed with us. So that's why we are in the position we are today. If we had a more cooperative approach initially, we wouldn't have taken such a line in our memo. Thank you.
I mean, it expired one way or another, right? Whether or not we took an aggressive approach, which I disagree with, we were asking for clarity on what our authority was, which we've now found, thank you, town council. It was expired. You just didn't do your homework. We wouldn't be in this position if you did your homework before the first meeting. So let me ask a question specifically about the actual content of the memo rather than my petty grievances about the mischaracterization. So in the memo, you say, quote, no changes are proposed in the ways within Danvers jurisdiction. But you've just said now, Attorney Samasco, that you are proposing some modest improvements to Trask Lane. So which is it? Are you proposing improvements?
As I said, we are restriping existing roads and adding signage.
So what's in the memo? Oh,
We are
sorry.
not widening roads, we are not redesigning roads, is what I meant to
So the
say.
memo from Attorney Bailey that says no changes is incorrect, because there will be changes.
I would argue those are no changes to the road layouts, which I think was what was intended.
Okay. Understood. The word changes might be ambiguous. So in terms of, from the memo today from you, Attorney Samasco, you said that, let me read this. In our view, and consistent with town council's opinion, the scope of review should be strictly limited to those intersections of Wayside Drive, Folly Hill Drive, and Wayside Drive Trask Lane. But town council today said that they actually didn't opine on that.
I think what I was referring to, again, we were not trying to mangle anything here. I think the memo that we received suggested quite strongly that the board's review was quite limited under the covenant. And so I am suggesting in my letter that that limitation necessarily limits the review to those roadways that are outside of Mass DOT jurisdiction and just within the town's jurisdiction.
Gotcha. And again, apologies because the reason for pestering on some of these questions is I don't have one comprehensive and consistent summary. These memos and what you're saying seem to conflict in some ways, and it's hard to piece it all together. Let me see if I've got through everything so far. So, okay, so we talked about the intersections, the improvements. So last question for Attorney Bailey. The last paragraph of the memo says, "We ask that you advise the planning board and staff to that effect," which is our limited authority, "such that the next planning board meeting can be more productive than the last." So are you of the opinion that our last meeting was not productive?
I am of the opinion that the last meeting, the planning board was stating that it seemed to think it had authority to deny this project. And I wanted to make clear that the board did not, and I wanted to make that point to your town council, who ultimately agreed with us. Let me take a step back. Seriously, if we had wanted to just pick a big fight about this, we never would have come to you. We would just said, we'd have blown off that covenant and said, we'll deal with it another way. But Corcoran is sincerely trying to work with the Danvers Planning Board, with the Beverly Planning Board. Yes, we have a project, and there are a lot of people who don't like that project. But that doesn't mean that we want to go and ignore comments and ignore input. We're here tonight in a spirit of cooperation. My job is to work with developers, and I've worked with Corcoran for 30 years, and there is no developer I've worked with who is more willing to try and work with the community on these types of things. So maybe we can agree to disagree about some of, the sort of initial underlying, maybe we didn't, do a good enough job of, explaining why we were here and, why we didn't really think there was authority. But our interest now is to try and work with the board on matters that are plainly within the covenant. If it were enforceable, that you have authority over.
Yeah. So, look, I've said this before at the planning board, I'll say it again, is, everyone's acting in their own interest. This is, by definition, an adversarial position. Applicants want to make money, council wants to get them as much as they can. We're here to represent the people. That's always going to have a bit of conflict. So don't take my question as saying, like, I can't believe you did that. But you can see how it's a little frustrating to read all these memos and see these, what I said are mischaracterizations when, our job here is at $0 an hour. So I'm reading these things and feeling like, wow, that's not my recollection of what we said, and it's unfortunate that I thought that wasn't productive, even though it compelled them to go do their homework. So I would just appreciate in future correspondence a bit more care in that regard. Let me ask this question then, which is, what is the sort of rationale for seeking release of an expired covenant? Like, I understand you're saying you're trying to be cooperative. You've been ahead of us already when we didn't know that it had expired. And so you'd like to just continue this and make some modest improvements, which is appreciated. But I worry a bit about two things. One being precedent. I don't know of any other time I've been on this board that we've voted on something that had no force. That sounds strange. But the second being that there's a bit of a predetermined outcome, right? We can't actually vote no because you can just walk away. We can only vote yes. And it just seems like it sort of biases the entire process a bit. And so I don't know if there's so much a question. I'm somewhat stating my own opinions about why I have some hesitancy about voting on this, but why are you seeking release from an expired covenant?
Well, the original reason was because a covenant shows up in the title to the property, and as part of your due diligence in getting ready for financing and selling the property, you try to clear up any encumbrances. Buyers, title companies want to see that as a paper record, not necessarily, they don't want to do what unfortunately we're asking you to do, which is go back and forth between all these legal memorandum and make a judgment, right? A buyer doesn't want to do that. They want to see it released. So that's why we came here to begin with. And, you know, in the follow-up, you know, we think that we have developed legal arguments now and a record that is sufficient to make a buyer comfortable on this, but that's why we originally came here. And, you know, as a practical matter, we'd like to get it cleaned up. It has no, if we all agree that it is not enforceable, and that I think what the applicant is willing to do here is to say, we will cooperate with you on a scope of peer review, and even though the covenant doesn't, you know, the covenant says that the parties need to agree on the cost of the peer review or whether the developer necessarily has to pay for it, we will do it as long as it is limited in scope. And I think the other ask would be to get a release of the covenant on the record to the extent that the board is satisfied that it is not enforceable.
Got it. Okay, that's helpful.
Tim, anything further?
And so is it right that, excuse me, we've heard the rationale for which intersections are included. We've heard you make mention of striping and signage for the improvements. Is it right that we would see that sort of formally represented once the peer review of the traffic study is completed? Right, that,
Yes.
okay.
Yep.
No other questions?
Jim, any further questions of the applicant of our town council?
So I just want to be clear. So are you agreeing to the peer review? Because
We
in
will
the
agree
letter that
to
we
a peer
saw,
review. You know, I made the case to the planning staff that really, if we're talking just about striping and signage, customarily, that would be something that would be handled internally. It seemed like the engineering department wanted no part of that. I heard from Josh this afternoon. That's fine, I get it. I spoke to our client. You know, if the peer review is limited, as we've suggested, and we can all agree on that, they will pay for that, provided that scope does not expand. So we'd like to see the scope before it's signed off on by the peer reviewer, and if so, we will pay for it. The town already has money on hand from the applicant, so we can get this going.
so you need
Is that clear?
a new quote reducing the scope.
Yeah.
The first quote was like, what, 13 grand or something? So reducing the scope to just those two roadways.
Yes.
Getting that and then going forward.
Yep.
And then just a quick comment on behalf of Tim, I mean, and just for further clarification, the reason why, as Tim mentioned, you know, this is a very rare thing for any board, and we have some members who have not been on the board for a long time. I have been on the board for a long time, and I can tell you, it's the first time I've seen something like this. So I think to ask the town council to be present to help us and assist us with, you know, some edification and some guidance was prudent. You know, what are our options? Can we, you know, deny something or put in further control? So I think it was a prudent thing to do, and it wasn't meant to, you know, slow down the process. And I'm glad that you did come in front of the town, even though you didn't necessarily, we found out that you needed to, but I think it's helpful to get it out there and to explore it to the extent that we're able to. So
I appreciate
just
that.
to, that's it.
Okay. Jean, anything further for the?
No.
Mike?
All set, thanks.
Yeah, the only thing I would say, and I think he answered the question I had with respect to the, you know, into respect to who would be performing a peer review in terms of, you know, either would be town engineering staff or outside reviewer. So I'm happy that having, you know, that with the town engineering staff not, you know, being able to do it, that you'd be agreeable to having the private peer reviewer. And just sort of, just also to pick up on some of the the comments that were said a little bit earlier in terms of, in terms of the previous meeting, and really, I mean, I think that the board's intention was really to, I think this is not something, as was said, that comes across as, every day. And I think that this is something that, so I think respectfully, we wanted to get additional information, which meant in terms of getting additional information from town council, in terms of seeing what indeed could we do. And so I think that, I don't see there was any sort of preordained, intent or feeling from the previous meeting. It was just to get answers and to find out what was the scope of our jurisdiction with respect to the covenant. And so I'm glad that the applicant is cooperating and has come to us as well, and we'll be able to find out further on this.
The one?
Here, go ahead.
Josh, I don't know, I know I mentioned that if they go to put 300 more units in here and Beverly okays it, then we still have nothing to do about it. Is that something that we should look at as a town to avoid this in the future, or not avoid this, but to have, I guess my point is if they go to do 300 more units, they're not going to come back to, or they don't have to come back to us. So is it just is what it is, or
Can I jump in on that?
I was asking town council, but after.
Yeah, why don't we ask, you want to ask town council?
Yeah,
Or Josh, it's up to you where you want to defer.
I mean, I could take a stab and then get corrected, but.
Yeah, okay.
But if if the project's not, that we're jurisdiction, that was, we keep talking about, I mean, if it's not in the town of Danvers, I'm not sure how, we would be able to, opine, or, what would be the application in front of the Danvers Planning Board?
I guess forgive my lack of legal knowledge, but why was the covenant created the first time? Was it because the road was created, or what was the reason behind it?
Yeah, correct.
Okay, so there's not a covenant that could be created because there's no road being created or anything like that? Is that in layman's terms?
Sure. I mean, there's lots of different legal layers and legal instruments for all sorts of things, but yeah, right, because there's not a new road being created, right? There's no subdivision, there's no covenant, so.
Our town council, do you have something to add to that, or?
I actually agree.
Okay.
Okay.
You agree, okay. And
Can
did the applicant
can
have
I-
something you wanted to say as well? I wasn't sure if I heard.
Yeah, Dan, if I could.
Yeah, Peter, please go ahead.
Could you
Peter
identify
Mahoney.
yourself, just?
Yes, yeah.
Thanks.
Peter Mahoney with John M. Corcoran and Company.
Great, thank
I
you.
just want to clarify, in terms of our project and our 80 acres, we've already been very clear with the city of Beverly that, the 440 unit proposal that we have on the table is what we have on the table. We've talked in behind the idea of either a covenant or a restriction to prohibit future development on the rest of the parcel that we control. Obviously, there's other landowners up there, we don't control those, but if there's concern about the extra land that we have as part of our project and future development, you can rest assured that we've committed to no further development there.
And that's a deeded, is that part of the,
We're in the process, obviously, and so, we'll have to work out the mechanics of how it works. But there's some trails out there where we've committed to trying to make those available to the public, beyond the scope of where our buildings are.
okay. Okay.
I have a question.
Yeah.
Will that expire in 30 years?
I can answer that.
Yeah, I'm not the lawyer. We'll make it.
Yeah, no, I mean, one of the exceptions to the 30-year expiration is a conservation restriction that runs to a nonprofit conservation organization. So mechanically, the way that it works is Corcoran would continue to own the land, but there would be a conservation restriction running to Greenbelt, some trustees organization, potentially the Beverly Conservation Commission, but some nonprofit conservation-minded entity that would hold a restriction that prohibits any further development or any further structures, improvements, etc., on the areas that are not the subject of development here.
Thank you.
And I mean, just to elaborate on that, ultimately that type of CR has to be approved by the State Department of Conservation Services, which readily approve them. It's not a big deal, but that's how you make it permanent.
Good, thank you. Just one other, just a follow-up question. I know we're talking about various approvals, and the state just rung a bell in terms of Mass DOT, or I guess, it's the predecessor, Mass Department of Public Works back in the Covenant days.
Yes.
So Mass DOT, what is the timeline for potentially for the approval? Where are you in the approval process there? Because I know you mentioned that there are these other approvals
Yep.
that are dealing with a lot, some of these other intersections.
Dan, I think you might be better off explaining where that stands with MIPA. I don't.
Sure. Happy to. As Miranda and others have explained, we are in the MIPA process, which means that the project has submitted an environmental notification form to the state Massachusetts Environmental Policy Act office. That environmental notification form resulted in a certificate from the Secretary of Environmental Affairs that said, here are the things that you need to study. One of the big things that we needed to study was the traffic impacts. We have done that, and there is now a draft environmental impact report that we submitted 3 weeks ago or so, pending before MIPA. The comment period on that environmental impact report expires, I think it's February 14th. Maybe it's February 7th, but it's sometime in February. And that is where Mass DOT collects the comments from various interested parties, and MIPA collect comments and evaluate those comments, and ultimately Mass DOT will have to issue what's known as a highway access permit because of the proximity of the project to Route 128 and the amount of traffic that will be generated on Route 128. And if you want to get even a little more wonky, Rebecca's here, and she can really drill down on the details on average daily trips and all of the other things that require Mass DOT approval. But ultimately, the project needs a highway access permit from Mass DOT.
And you mentioned, Attorney Bailey, that there was a comment period. Is that a public comment period? So if people are interested in making public comments, they can do so?
Absolutely.
Okay. And how would they find out the link for that, or how would they find out where they'd be able to make a comment?
If you need it, we can provide it to you. We'd be happy to do so. But if you just went on MIPA, Google Mass, Mass Government MIPA or Mass Environmental Policy Act, you will get all the information you need to make those comments.
Okay, if you can provide that also to town staff, I think that would be good.
Town staff have already been engaged in the comment process, so.
Okay.
Yeah.
Could I just ask a question of Josh as far as, do we have essentially a motion to be made that we're voting on, and do we have just for belts and suspenders for the title, for the applicant, would we be signing a release or someone for the covenant for what they need for title purposes?
I can comment and give a little bit of guidance, because this conversation wasn't sure exactly where this was going to go. A lot of moving parts and people involved. I think where we came from was there would be some type of motion on some type of scope, whether it be third party. It appears, as I informed everyone, it appears that town engineering staff is not available to do it. So I think we're both groups is talking about a third-party peer review, and I think what we're looking for guidance for staff is looking for some type of motion indicating what is the scope that the planning board wishes to move forward with. The development team is clearly proposing in the language they're saying, limited scope, those two intersections. So the board could do a peer review with those two intersections that the applicant is clearly, in agreement. That's what they're proposing. I guess on the table is, not that this is my recommendation or just informational, but if the board wishes to, move forward with the third-party peer review that includes more than those two intersections, then clearly that's, decision tree that is possible, or they could do that, but clearly there are probably ramifications for that, going that avenue. So, does that answer your question, Jim? I don't think.
I guess in somewhat, but I think if it sounds like we're limited to the two streets and the peer review, which they're agreeing to. So the question is, do we, after we take public comment, which we haven't done yet, but do we, vote on a motion that's all-inclusive in the sense that it, subject to the peer review, assuming that's adequate, does that grant the approval for the release?
Right.
Or do they have to come back
Yeah.
for an additional meeting, I guess is the question.
I think that's where I said yes.
So it's to come back for a so it's a two-parter, like do a motion for a peer review and assuming that the board agrees to like a limited scope peer review, and then coming back after the peer review is completed?
Correct. That's how I view the situation moving forward.
Yeah, I would say in fairness, the only request we have in front of you is the original request, which was for a partial release of the covenant. So, I think now, in light of what we have learned, we would amend our request, but we have not yet done that. We wanted to have this conversation tonight and see where we all are. But I think we would amend the request for there to be a release of the covenant in exchange for completing the peer review.
So take it further, you were asking for essentially a full release, not a partial. What were we partially releasing?
I mean, it was partial before because we were assuming it was enforceable for the sake of trying,
Partial in terms of, because we were looking just at like paragraphs 13 and 14. Was that why it was
exactly.
partial?
And there were certain conditions that were continuing and there were certain conditions that would have expired. And we
Okay.
were dealing with it from a conveyancing standard,
Sure.
right? We
Yep.
were just trying to get it cleaned up. I think now with the new information that it's not enforceable, we would ask the board to consider granting a full release. If not, we would be happy with the original partial release that we proposed. But I think it muddies things unnecessarily if you've got something out there that's not enforceable.
Yeah, and then, so if you ask for the full release, contingent upon this peer review, the peer review comes back at our next meeting, I don't know how quickly they can do it. What's the point at that point, I guess, for the peer review? I mean, what are we going to?
Well, I'm not asking for it now. I think we would ask for it after.
What are we gaining from the peer review?
Well, I think
What are we,
what
I'm
we
just
are, what we
asking.
are anticipating from the peer review is that they will issue a report.
Yeah.
We will respond to it. We will come back here and answer questions from the peer reviewer and the board.
Okay.
To the extent, I think the peer reviewers' obligations are to, make sure that GPI has the correct information, so there aren't mistakes that are made, that we've appropriately considered Town of Danvers regulations, right? And so if they find that we haven't, we would be on the hook to correct that.
Okay.
So I think we're not saying it's a moot exercise. I'm just sort of forecasting that, given what we've learned, I think we'd amend that request to be a full release. And assuming we're all working cooperatively together,
Right.
then I think that's a reasonable.
And what's the
approach.
timeline, Josh, to have the peer reviewer act and get us a report so they can be reviewed? What are we looking at for time?
So there's a lot of moving parts, clearly, from these conversations. Depending on if the board agrees to the scope that's proposed, or a modified one, or any of those scenario, any type of peer review, I will have to, from a staff's perspective, I will have to reach out to the private consultant that was going to move forward with the larger one, and at least, that it is a significantly different kind of exercise, right? So I guess if they're, with the new revised scope and send it to them, if they are willing to do it or not, or, potentially, there's a lot of different scenarios. So that obviously I would have to have a conversation with them, this is a new scope, is this something that you're still willing and wanting or available to do? And if the answer is yes, then we just proceed. If not, then I guess we'd sort of have to start the process in a way, again, with a much smaller scope.
The only thing I wanted to add as well, just with respect to the limited, release versus the full release, I would just want to make sure that there's, because our consultations from town council that related to the, it's more of a reservation, just, is that our consultations with town council related to the paragraphs 13 and 14. And so I would just want to I would want to be certain that if we are releasing if we're releasing the entirety of the covenant, that there is not one paragraph there because of some language in there that might differ from 13 and 14 that is enforceable.
Yeah, I think that's fine.
That's the only thing I would want to make sure before we went forward with that we got town council sort of blessing that. Okay.
Can I ask one more question?
Sure, yeah.
Josh, are you able to pull up the list, what you sent us, the list of the intersections?
Yes.
On the screen?
Yes, one moment.
I just want to double check because there's 20 intersections in Danvers, and I just want, we sort of glossed over why some of them are being excluded. Just want to make sure we're super.
Sorry, just for informational, they're not all 20.
Sorry, yeah, there's
sorry.
20, and it's a subset of those are in Danvers. My mistake.
But still like me to bring it up?
Yes, please.
Yes, sir.
Just because I think we know why we're down to the 2, but I just want to make, they're numbered, so we might as well just go through them.
One
for the
moment,
record.
please.
And maybe just to because I think what I see in the memo is the December 2nd memo. Route 128 as well as the access ramps associated therewith are within Mass DOT's sole jurisdiction, excuse me. And so I think that's why intersections 2 and 3 as well as 19 and 20 would be, sorry, I'm getting ahead of myself, but I get anxious.
So you're trying to figure out from this 20 why it's down to 2 in your mind?
So, yeah, 20 minus
Right, 18.
the 8 that are in Beverly.
So I believe, the Beverly ones are not in bold. So
let's go through them. Elliott Street and State Road. I don't think that's a 128 access ramp, but is that still within Mass DOT?
yeah, because it's a state Route 62.
Right.
So anything I believe that touches Route 62, and Rebecca, if I'm wrong, feel free to chime in.
Yeah, so the state's jurisdiction does extend from State Road all the way through Liberty Street there, because those all operate as a coordinated signal system. And the State Road intersection actually operates on the same traffic signal controller as the southbound ramps. So that's why that's all under Mass DOT's jurisdiction, that numbers 1 through 4.
Great. And then 5, 6, 7, excuse me, you had mentioned that the Beverly peer reviewer had agreed that there was no impact on traffic, and so those are being excluded by virtue of us just trusting that finding and not having our peer reviewer also look at that. Correct?
That is correct. That, yeah, based on routes that actually lead to and from the site, there really isn't any reason why someone entering or exiting the site would travel through those intersections. So that's why we have no impact there. The number of people that would travel through there would be negligible.
Okay. And are we all comfortable with that? Because a peer reviewer would check that, right? That would be part of a peer review process, but we're comfortable just taking their finding.
I mean, they could probably just provide us with the Beverly peer review, right? You said there was a peer review done of those sites?
Is that
right?
something you could share with us?
Yeah,
That'd be good.
we can do that.
All right. And so then
And our distribution will get reviewed also by Mass DOT
Great.
as part of the MIPA review process. So it'll get reviewed twice.
Okay. And then 8, 19, and 20 are all, again, Mass DOT. That leaves us with 17 and 18.
Well, 19
That
and
is
20
correct.
are what they're agreeing to.
There's two
No, 17 and
19s.
18. Sorry, Lou.
18.
Right.
Okay. Sorry, just want to make sure we were clear on all that. Thanks.
Anything else from members of the board before I entertain any public comments? So if any members of the public have a question, why don't you just come up to the podium and direct any questions through the chair? And again, this is a good opportunity as well, because we do have the development team here as well, so that hopefully they'd be able to address any specific questions you have as it relates to traffic or what have you.
Great, thank you, Mr. Chair. Joanne Wheelock-Waguchi, Town Meeting Member, Precinct 2. My first question is, does the town have any position to insist upon or to ask that the developer more so explore the alternative exits and entrances in Beverly rather than Danvers? Can the town do that? That's my question. I'm not sure if it's for our council or... My question is from the town's standing, do we have any right to ask or even insist upon the developer to explore the alternative exit and entrances that were in Beverly, that were briefly mentioned here in the meeting tonight? I think one was through the golf course, and one, I can't remember where the other one was in Beverly.
Might have been addressed as well before, but the town council can say, and also if the applicant has something they want to add to as well. Do you have anything to? Why don't you go to you have to go to the podium, yeah, sorry.
Or you can, whatever.
I have a few questions, so
No,
we'll
that's fine.
do
You
them
can-
at a
you can,
time.
yeah, just stand by, yeah, that's fine, yeah.
I don't really have an answer to that. The applicant can speak to it, perhaps. We haven't looked into that matter of alternate entrances.
Okay.
I can tell you that the City of Beverly's position, expressed consistently and strongly, is that they would not allow those other access points to be used for anything other than the emergency access that they currently are.
So you
So-
explored that with the city of Beverly?
We have, yes,
Okay,
yes.
okay.
So with that answer, I would ask the town to insist upon the City of Beverly to explore those exits and entrances and to rethink their position. Reason being, I'm going to speak from, I would say, a strong majority of the residents here in Danvers. And what I continually hear from my constituents and constituents in the other precincts is the traffic in Danvers has already become unbearable. Route 62 and so forth, it's already a roadway. Even Conant Street, that should be included, I think, too. But even Conant Street, those intersections are just, commuting times are, you can't get through. It's really a nightmare. It's not only, it's a public safety issue, I think, too, if there's a medical emergency or another emergency. So I would really hope that the town lean on Beverly to really look at those alternatives. Another reason being is, my question is, does the town of Danvers get any developer fees from this project, where we are signing over these two roads of town roads to access this development?
I believe. Josh, town staff, any?
I'm not sure what you're referring to by, what was the term? You said developer's fee.
Danvers has a developer's fee. I think one goes to transportation, and then if we...
Or like a project.
Yes, and affordable housing, whether we get, I think we'd get units, so...
Right. No, not to go too into it, but the transportation fee is only for projects downtown, and because the project's not located in Danvers, we would not be receiving any. I think that the project is offering and proposing affordable units, but
Okay.
it's not,
That would be for
it's not
Beverly.
technically for the town of Danvers. you know,
Right, that would be under Beverly's umbrella.
Danvers residents could
So-
apply for it and, you know.
So Danvers would get $0 from this development. Am I correct? No tax dollars are going to
Yeah.
come to Danvers, not going to be funneled through Danvers, no developers' fees, nothing.
I guess the way you're
Am I,
portraying it.
am I
that's-
correct? Well, I'm just wondering, is there any other monies that are going to come in to Danvers?
It also will not be taking
Yeah.
any, in terms of schools
Right.
and
Oh,
utilities and such will not be.
Right.
I mean, there'll be
And I get-
Beverly.
right. But we do have the liability of keeping up those access roads, which we do now, but I think with the increased traffic on those roads, there's going to be more wear and tear on those roads. So down the way into the future, there's a financial liability to Danvers. Possibly, probably. I just want to bring that up, whether it's, I know it's probably out of your scope, but I want to bring that up
Just
for the
understand-
town. Yeah, I'm just mentioning it, because I know there's not much you guys can do about that, but, so that's a concern. Again, I can tell you the residents of Danvers, have the abutters on these roads been
Yes,
notified of this project?
yes.
Okay. Have you heard from a lot of them?
We received a couple public comments or letters. but-
Okay, and may I ask just briefly
Yep.
what the feeling of those comments were?
I guess to paraphrase, you know, sort of, you know, not necessarily, you know, this, the typical concerns that you would think or be concerned about for a project, you know, of this size being
Okay.
located next to you.
Right, so that means that their quality of life is impacted.
Here, I could,
It's not a question.
not to paraphrase,
It's
I
not,
could-
no, that's okay, it's not a question. I can
I
kind
could
of,
find them in a moment.
yep,
Just give her a moment.
Yep,
yeah,
that's
just-
fine.
Just give Josh a moment. I have them handy here, Josh. too, if they-
I have
these are-
3 of them.
There were 3 public
Do you
comments.
want,
Okay.
would you like, do you want me or you to read them, or, I don't know?
Why don't you, Josh, why don't you go ahead?
Okay. So here's one from just Tom McDonald. He doesn't give his address, but regarding the 440 dense packed apartments contained in 6 buildings planned to go in and spill out onto Route 128 with no other means of egress, gives nothing to the town of Danvers except more traffic, clogged intersections, and resulting accidents and aggravation for all concerned. Beverly has already unequivocally said that they will never open this development to an additional egress onto Elliott Street, and so to this, I would remind you that they will be putting 880 parking spaces for 880 more cars, but what about Super Bowl Sunday, game days, visiting friends, celebrations, birthdays, you name it, and yes, it's going to bring in even more traffic, and it doesn't matter if Beverly did open Elliott Street, as the result would be the same. Printing more lines on the street and adding 43 seconds to a traffic light won't do anything either, except generate more traffic caused by the signal delay in that direction. Danvers has the power to stop this, and I believe we should, by using the power of what we were given in the original covenant based upon safety. Also of note is the placement of Site A and Site B being neatly tucked in with the existing development, which creates much open space for even more future expansion. What we do now will change the fabric of our community forever and set a precedent for future development. Thank you for your time. Sincerely, Thomas McDonald. So that was one of 3.
Yep.
But
And we received 2 others,
2 others.
put them on a screenshot, and
Yeah, sure.
we don't need to, I don't think we need
Yeah.
to read them in full.
So-
just-
Okay.
Just address briefly their concerns.
Yeah. So there was another email from Matt Jones. Similar kind of concerns about the traffic. And then there was one more from Beatrice Hines at 17 Kona. Oh, it appears she's a Beverly resident.
Yeah, she was
Just,
a Beverly resident, but
Right.
she
right, reached out to us.
expressed her concerns. Mhm.
So similar, like traffic concerns, not necessarily in favor of the project.
Okay,
So-
which I thought they would be. So I can't strongly stress enough that I hope the town takes some action to look at alternative exits and entrances that go through Beverly, that do not come through the town of Danvers. We have too much traffic for our roadways to handle as it is now. We do not have enough officers in our police department to handle the public safety needs as Danvers is right now. I don't believe, even like they say, Conant Street, I think the traffic study should be even more expanded because it's going to impact more of the town. People are coming from different work sites, whatever, different activities. We have a mall, we have many things in Danvers that people can be coming to and from. You have the Cummings Center in Beverly, people are coming in and out of, with work-wise, appointments-wise. I strongly hope that the town can insist upon that this should stay in Beverly. One quick fact, I was reading at the end of the year, and this is just a quick comment, Money Magazine puts out every year the list of the worst communities in each state. In the top 20 this year in Massachusetts, I think they were 15 or 18, I'm not quite sure. Beverly showed up on it. And the reasons why is because of overdevelopment, lack of infrastructure, and the traffic. And Danvers already has the traffic. Danvers already does not have the infrastructure to handle any more. And we are looking at our own overlays where we're getting development now too, that we have to be careful of. So I don't want to see Danvers ever in the top 20 in Money Magazine. So I really hope the board can take my comments under consideration. I see the concern on all your faces, and I appreciate it, and I know you've gone through this, but this is a big concern. So thank you for letting me comment.
Absolutely, thank you. Any further, any other comments from members of the public? Okay, coming back then, what's the will of the board? Looking at I think we're looking at would we be, it looks like based on talking with town staff that we would be looking at going forward with a peer review.
Yeah, I think we need to do a motion. I would make a motion that we accept the peer review in the limited scope of the two roadways, I believe, Folly Hill Drive and Wayside Drive. Upon completion of the review, then I would, expect that we would have a further motion to release the covenant, either full or partial, based upon town council review, whether there were any lingering, effects of the covenant that might carry beyond the 30 years, which I'm not sure there would, but we'll get opinion on that from town council, I think, just to be comfortable. And, we'll go to a further meeting based upon the reviewer's agreement to the smaller scope and subject to their agreement to the more limited scope, and then, receiving and reviewing said peer review.
Okay. It's a motion. We'll have to
Not
go,
too concise.
we'll have to go for the video for that one. Okay.
Before we vote, can I add a comment? Am I interrupting?
You can amend, or you
No,
can-
not to amend it, just to put some information out there about the MEPA process. So I saw that the DEIR was submitted December 16th, 2024, and public comments are due February 7th. So town meeting members, I know that Brian has already submitted a letter. Just since it's really out of our hands with the traffic, that's more in MassDOT's jurisdiction since it's the state highway. So anybody that has concerns, I think that that avenue would be much more helpful because there's not really a lot that we can do. So if you really want to get your voice out there, then that would be like the next level up to voice concerns. Thanks.
Thank you, Jean. Okay, so we have a motion.
Sorry, I'm not sure if this is the best opportune time, just before we vote on this motion. Just one thing I want to bring up, just because Attorney Samasco brought up the potential full release of the covenant. On our agenda, we call this trash lane partial release of covenant and haven't been using full. And maybe this is a question for both of you, town council as well. I know this is an administrative matter, but sort of how we've been advertising, we didn't necessarily have to advertise it in the paper or notify abutters, but when we did the notice paper and send mailings to the abutters, we always used partial release of covenant. So if we were to go for the full, are we talking about potential, I guess, in either of your opinions, are we having to start this whole process all over again? Or
Advertise? Yeah.
or like, could we,
Sure.
I guess your thoughts on this, and maybe town council after you comment if.
Yeah,
thought-
I mean, as you'll recall, Josh, we had this conversation from the get-go, that this is not a public hearing.
Right.
You're required to notice the agenda and make sure that everybody is aware what's on the agenda.
Right.
And I think the town understandably went beyond that and sent
Sure.
everybody actual notice. However, it is not a public hearing. I think that procedurally, amending in a public forum, the request to make it a full release and then publishing when we do come back with the request, having it published on the agenda as a request for a full release would be absolutely fine. Obviously, you're going to have to take town council's view of that, but that would be mine. And also, I would just, I guess, reiterate, we're fine proceeding for this evening's vote as a partial release. You don't have to reach the issue of the full release. I'll submit something after the record, after this meeting, after we've talked with town council about that as well, and we can address that separately.
And I think also for the record too, I think that Jim's motion, I think, covers sort of the two-step in
Yes.
terms of the peer review, and then based on then later on, it'll be either a full or partial release based on input from town council. So I think that covers,
I thought so as well.
possibilities.
Yeah, I think so.
Okay. Does town council have anything to add before we?
Yeah, I would like to look into the matter, and I'll get back to you on that.
Sure. Okay, no, that sounds, so we do have Jim has made this, the motion with respect to the peer review, along, sort of providing also sort of the roadmap for future, sort of the future action. So so he's moved, is there a second on his motion?
Second.
Okay, second by Jean. Okay, very good. Any discussion on this, on the motion? Okay, hearing none, all in favor, please say aye.
Aye.
Aye. Any opposed? None? Okay. The motion passes.
Okay.
Okay.
Thank you very much.
Thank you.
Okay.
Okay. Okay, see you soon. Okay. All right, let's move on to our next agenda item here. Oh, and Josh, just for a purpose, do we need
Yes,
to
yes.
set a
Yes.
next?
Yes.
We need
So
to continue this, I'm sorry, I
Yes.
jumped the gun here.
Yes. Sorry, no, thank you for
Yep.
that. So,
We need to set the next hearing.
just,
Because
so-
this hearing, not hearing, this meeting does have to be continued.
it does, we do need to send it to a date certain. So our next meeting, scheduled meeting is January 28th. And then the next one is in February, I was just looking at it, February 11th. I guess in consultation with the development team, if there was a preference between those, or if there were things that need to be figured out
I
offline?
think
or-
maybe, given where we are, we should just continue it to your next meeting and keep it on the agenda. We can check in,
Sure. And
see
if-
whether there's a peer review at that time.
And if not, then continue it to the, yeah, just,
Yeah.
okay.
Okay.
That
Does
seems.
that make sense?
That seems,
So we'd entertain a, Jean, can we entertain a motion to continue it to our next meeting?
So moved.
And that would, the date would be?
January 20, what'd you say, 4th?
28th.
28th.
14
Second.
days from today.
Yeah, 28th.
Okay. Very good. It's been first by Jean, seconded by Jim, to continue this to our next meeting of January 28th. All in favor, please say aye.
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 Any opposed? None. Okay, the matter's continued. Okay, thank you. Have a good evening. Okay. We're going to move on to our next agenda item. This is a public hearing. This is with respect to the zoning bylaw amendments, and will be an overview from staff of the proposed zoning bylaw amendments for special town meeting, February 3rd, 2025. The public hearing is regarding several updates to the following sections of the Danvers zoning bylaw for purposes of clarity, consistency, and reflection of current Massachusetts regulations. Section 4, site plan review. Section 7, dimensional regulations. Section 10, off-street parking standards. Section 18, character-based zoning districts. Section 27, groundwater protection district bylaw. Section 30, special permits. Section 31, floodplain overlay district. Section 37, sign bylaw. New Section 38, outdoor lighting standards. Section 40, definitions. Table 1, table of allowable uses. Table 1A, civic space district, schedule of uses. Table 2, table of dimensional requirements, residential. The hearing also includes the following proposed, we'll hear from Josh on this, includes the following proposed zoning map amendments. One is to include 141 Pine Street, map 50, parcel 87, and 146 Pine Street, map 50, parcel 98, into the Tapleyville overlay district. This would not change the underlying zoning district, which would remain residential 1. The other zoning map amendment includes moving certain town-owned parcels from civic space institutional, CS to civic space open space, CSOS, zoning districts, and the inclusion of other town-owned parcels into the civic space open space, CSOS zoning district. Okay. Josh, you want to say a few words? I know we had there was a select board meeting last week on the warrant.
Yep.
And
I
so,
was thinking about, I was thinking about maybe just going through them briefly, or instead of just going over them, and then as we get to each article, I could comment on something happened at select board or not. Would that make sense, or what would you, oh, sorry.
I mean, I think that would be fine. I mean, I know one of them is.
Yeah, okay, if you-
Select board
sure.
action is not,
Sure, so if we want to start with that.
just so people are aware
Yeah.
before we start going through all of them, that,
So the article, I didn't, the proposed article regarding the Pine Street 141, 146 rezoning was removed from the warrant at the select board meeting. So I have the warrant in front of me right now, and that article is not been removed, so.
has been removed.
Has been removed.
Right.
So it will not be on February 3rd town meeting. So,
So hence it will not go before FinCom and,
exactly. Yep, no FinCom, not gonna really talk about it tonight in depth for that
but
reason.
ultimately will, the meeting today, though, if there's any comments or,
Right.
changes, or, recommendations, then that would go to FinCom for their meeting this coming Thursday.
That's right.
Okay. Got it. Okay.
Would it be beneficial, I guess, for me to just go through them? Like, again, I know we've talked about it a couple times, but,
I think just for purpose
Sure.
of members of the public as
Sure.
well, I think that would be good to briefly walk through them.
yep. So this is February 3rd town meeting, 2025. There's a couple general bylaw articles. These are the zoning bylaw amendments. The one that we just discussed, the Tapleyville Article 6, was removed. So first, let's talk about one of the ones was Article 5, has to do with kennels, and we basically are proposing to adopt the state definitions for kennels. And I guess from a policy change, the big change, although it's a modification, is just what we're calling a personal kennel. It's more than four dogs. So someone now can have 4 dogs at their house and not need to go to the ZBA, but they would at the 5th dog. So that from a policy standpoint, that's probably the most significant. All of the new definitions, just for the board, I did print out Word versions in red line of everything that I'm discussing. Sorry, didn't mean to.
Yep.
Forgot to bring that up. And then,
So that's Article 5. So
That's
we want to
Article
walk through that and see if we have any questions from the board?
sure, I guess one other just to comment on that is the use table and all these new definitions were added to the use table. And the personal kennel, if someone ever had 5 dogs or more, needed a special permit, that would always go to the ZBA. But for all other kennel-related special permits, it's sort of what most of our use table is set up in that if they require a special permit and it's in a residential zone, it would go to the ZBA. And if it's a special permit in a commercial zone, then it would come to the planning board, which is generally how our use table is generally set up. Most of the, like what special permit granting authority, who usually is granting that special permit. I guess I'm open to questions on
Okay.
Article 5.
Any questions from the board on Article 5 dealing with kennels?
I don't have a question, I guess. Josh, could you just give a super quick explanation of like the review process of this? We obviously went over this. I thought it was the last meeting, but maybe it was 2 meetings ago. So is it the same thing that we're going through? Is something changed? Like, was there a certain amount of time
nothing's
we
changed.
have
Nope.
to go through this? Or I'm just trying to understand.
The select board did not change any, nope, sorry. The select board did not make any changes or modifications to any of the language other than just removing that Article 6. Nothing that was presented or discussed has changed from our prior meeting.
So is this just a general conversation for the public more so than for our board since we've already reviewed these, or? I'm
Yes,
just trying to, okay.
just an overall,
Okay.
summary, yeah.
Okay.
Yep.
And I think it's a good opportunity as well, if there were questions that were raised by members of the select board, or if, let's say, the select board amended a
Right.
provision, rather than removing it, it would come back to us and we'd be able to weigh in with some comments that could go to FinCom.
Agreed, but you're saying there was no changes other than the removal of that one?
Correct.
Okay.
Correct.
So everything else didn't change, no comments are on that?
No
Okay.
changes to any of the language.
Okay, thank you.
Yep.
Any other?
Can I just ask, what was the feedback on Article 6? Why was that removed?
I was at the meeting, so I can.
Lou could also comment, but what I've heard is that there were a couple of people from the public who expressed concern about changing the zoning and what the ramifications would that be. And I think from the select board, not that I wasn't there, maybe Lou could answer a little bit better. There was sort of just this, we don't have enough information to make an informed decision. So let's maybe have a little bit more public discourse on the matter, and then maybe we could vote on this in the future. Lou, I don't know if I articulated that.
Brian Zakelli was there,
Right.
and he presented, just a moment, and he presented the similar presentation that he gave at our last meeting, and talked about sort of what, the concerns, I think, that it was intended to address. There were resident concerns that were brought up, specifically, I think, related to concerns of the surrounding area on Pine traffic, that there should be a traffic study done, and that there should be just additional review of it. And then the select board voted to remove it from the warrant.
Okay, thank you.
Just one other comment, it's sort of similar. In the agenda where we mentioned that the other zoning or not, the other thing that was removed from the select board, I guess I misspoke earlier, was we were proposing to move some of, in the civic space, there are 3 zoning districts within civic space, and we were proposing to move a couple of them from institutional to open, to what we're calling open space, because they weren't developed. They were general parks or playgrounds or forest. And I believe Brian just indicated to me, that was also, the select board also, I think, took that also off the warrant. So that was, so it was Article 6, which is the Pine Street, and then the civic space stuff was also removed. So those two things from the original agenda, the original legal ad, those were the two things that were removed, and that is also not in the warrant that I'm holding in my hand, so.
Okay. And I think that there was a point in terms of, even in terms of staff, I think that it would anticipate that, Josh, I think that it would.
Sorry, just so many people involved. It was not from the select board, but it was an internal staff decision that it just didn't even get to that point. Sorry, I misspoke. I'm sorry.
For the citizen space?
For the civic space one, the select board did remove the Pine Street. Town staff removed the civic space.
At what point did town staff remove the civic space part? Because if I recall, the planning, we did vote for it to move on to.
I don't think though at that select board meeting was it even discussed that night?
I can't recall.
So I think that's why, because there must have been some reason internally why it wasn't ready, or there's something about it that wasn't ready to move forward.
But we voted on it, though.
It's not in the warrant, so.
Okay. Understood.
Sort of.
So civic space is still there, but just it was certain.
It's not in here now.
Okay.
So.
Got it. Okay. So in terms of, I think with respect to Article 6, the old Article 6, dealing with the Pine Street and Tapleyville overlay, I think it was anticipated that would come back at some, at some point, either a land use summit or something like that, to have further discussions about that.
Right. Yeah. That would be the appropriate kind of time to have that conversation, right?
Any other questions before we go on to the next article? Okay. Ms. Rigucci, I know you did you have anything you wanted to? If you want us to go to the podium and just, I mean, we aren't planning on discussing it further because it's removed. Sure.
Mr. Chair, I know you were at the meeting,
Yes.
too. So, Joanne Rigucci, Town Meeting Member, Precinct 2. So what I proposed last week at the Select Board meeting was to remove Article 6, the inclusion of 141 and 146 Pine into the Tapleyville overlay. There were a lot of concerns from the neighbors in Precinct 2 on the overlay encroaching more onto the neighborhood. Like you mentioned, traffic, the density, the already density of the neighborhood. It's quite a dense area of town. We have the ballpark right across the street in that area, so there's a lot of pedestrian traffic as well. The other concern is I have been in touch with the folks over at Rebecca Nurse, the Danvers Alarm List Company. They have concerns about it, and I believe, I will not speak out of turn for one of the members, but I know they're looking at increasing the setbacks for, in the Tapleyville overlay, in regards to historic properties. So that's another big issue. So there's just some things that we think need to be looked at, improved upon, before this is proposed again. And that's why we are glad the Select Board took it off at this time, and to give everybody some time to get together and to work together to make it more comfortable for the neighborhood, if in fact, it does come up again. So just wanted to include those comments. Thank you.
Thank you. Appreciate it. Thank you. Okay. Any further? Okay. Okay. So anything further on Article 5, which was the kennel? So Josh, why don't you briefly cover the next item?
Yep, so the next one is Article 7, it's garages. It's fairly simple in that we were just...
The new warrant, it's actually Article 6 now.
Right.
Yeah.
We're just removing in the definition of garage, currently said located on residential property. We were like, well, obviously commercial can have garages also, so we struck the language that just said that basically garages could only be on residential property. And then we were just amended the use table so that just in commercial districts, when you're doing, if you're proposing to do more than a 3-vehicle car garage, that it would be a special permit with the planning board.
Okay.
So that was
Okay.
pretty much it.
Thanks, Josh. Any further questions on garages from members of the board? Any questions from members of the public with respect to this article? Okay. Let's move on to the next one, Josh.
The next one is related to the floodplain, and it is now Article 7. It was previously Article 8. And this is just a complete rewrite of this section, and this has to do with flood insurance and properties that are located in the floodplain by the federal government. So this whole section was completely rewritten. It was reviewed and satisfactory to a FEMA official that we've been working with. And now there was a date in here that we needed related to some maps that are coming out, new maps. And the date we just found out yesterday, July 8th, 2025.
Okay.
So this is just a complete rewrite of this section in the bylaw.
So does that date need to be inserted
It will,
into?
yep, it will. We put it in as date to be determined mid-January, so that date will be included now.
Okay, so will that be is that going to be something that Brian in his presentation to Finance Committee
Yep.
will recommend that it be, amended with that date?
That's right.
Okay. Any questions from members of the board on floodplain bylaw? From members of the public? Okay. Hearing none, let's move on to the next item.
So this is, it was previously Article 9, now Article 8. This is a groundwater protection overlay district. And we're simply changing the date of the map, of this new map, to now be October 3rd, 2024. And this is because a new map is being referenced because there was a well that was taken off line in the town of Wenham. So in the corner of town, there used to be a corner that was in this groundwater protection overlay district that no longer, that portion of the map is no longer applicable. So we updated the map to take it out.
And it looked like it's replacing a map that was dated from 2004, so this is not the type of thing where it changes that frequently.
Yes.
Okay. Any questions from members of the board on that item? Anything from members of the public? Yes, go ahead. You can identify yourself and...
John Bouchard from Crestline Circle in Danvers. I brought this up at the select board meeting. That area up at the top where the well is no longer used. If you take this out of the groundwater protection district, that becomes prime territory for someone to develop. The other question I had is, if there is a well there that could be used in the future, where Danvers does have a water problem, it would be nice to maintain that. If we take this protection off, really they can build right over the top of the well if they want to. There is no protection anymore in that whole gigantic area. And that's a concern. Right now, it's just maintained as open space. And I'd like to see it stay that way. And I guess the question is, do we have to conform? I know this is reflecting the new maps issued by the state, but do we have to go along with the state, or could we leave that section up at the very top alone and maintain it?
Okay. Josh, what do you...
I mean, it's my understanding that, right, it's sort of an authority that's above us, in that, right, we are referencing, it's like kind of like a state jurisdictional item in that, you know, that if the state, you know, is telling us that this is what should happen, or this is like the map, you know, this is what,
We're required to reference the most recent
my understanding, you know,
map.
yeah.
But I think what Mr. Bouchard is pointing out is that the fact that that because the change reflects,
Yeah, so this is just an overlay, so there is underlying zoning, so it's not like, whatever, it's probably, I don't have the top of my head, but, in terms of development, it's not necessary, if the concern is, you know, significant development in the area, the underlying zoning is still, whatever, it's probably R1 or R2, it's not, we're not changing the underlying zoning in any manner, like, like attracting development in that area. We're not changing the underlying to attract development in that area. We're just taking away the groundwater protection overlay.
right, but if a well, so I guess what it's saying, so if there's a well that is currently existing on a 2004 map that's
Sure.
no longer, that's no longer reflected, then you would, that just by operation of the well not being shown on the map, that protection doesn't extend anymore.
That's my understanding, yes.
Okay.
Does that protection remove development though, Josh? Like what does the protection actually mean? Like
Yeah, I mean, there's definitely uses that, it doesn't stop development, but if you read the section, it definitely limits some types of use. There are, because it's protecting groundwater and drinking water, there are a number of uses in that section that.
It makes it
limits.
much more difficult to develop.
Yeah. Well,
The way it is right now.
Sure.
If you remove that, it makes it much easier to develop.
Because you don't have that same protection anymore.
That's correct.
Right.
And that's my concern. Do we really need to conform with the state map? Why can't we just leave it like it is? There is a usable well there. Who knows if we may need it at some point in the future. But if you take this off, that all goes away.
But if we decided to add a well there or a surrounding community, then it would be added back to the map and then it would come back, you know what I mean?
Or does the new map incorporate, does the new map incorporate additional protections which may not have been on the previous map?
Just one moment.
I guess what's the harm with leaving it like it is?
Just trying to figure out.
I guess on the other side, like what's the harm of changing? And I'm not saying I agree with it, I'm just trying to
Just
understand.
saying, you remove, if you tried to do any development in that area now, it's virtually impossible.
So it's because you're anti-development, is that a correct statement? I'm just trying to understand.
I'm just trying to limit the amount of development.
Okay, all right,
That's
just so I
fine
understand.
territory.
Sure.
That would be developed. And it would be much more difficult the way it is right now. I'm not saying that they can't develop it, but it'd be much more difficult. If you take this off, it becomes much simpler. It's just a nice-looking, open piece of land.
So I wouldn't say that it necessarily,
It's the swamp off
Uh,
Connor's Farm.
so it
Swamp
wouldn't
off
necessarily
Connor's Farm.
stop or thwart development if that's a concern, but things that I think that most of us would agree probably don't want to be near drinking water. So the following structures and uses are prohibited in the groundwater protection district: landfills and open dumps, automobile graveyards and junkyards, facilities that generate, treat, store, and dispose of hazardous waste that are subject to, household hazardous waste centers. So I don't know if it necessarily stops by removing this or keeping it on. It doesn't necessarily stop development or make it less attractive. There just are a number of things that it definitely doesn't allow.
So you can still build a house in there whether it's protected or not protected, is what you're saying?
It appears that way.
And then just to confirm, this area is basically Connor's Farm and swampland. Is that a pretty accurate statement from the map that I'm looking at?
That's sort of my understanding
Yeah.
in this conversation.
Okay.
And Connors Farm received
Yeah, tax. Farm.
agrarian, agricultural restriction. They received well over $1 million to keep it a farm years ago. So that's not going to be developed. That site will not be developed. I think if the motivation by town staff is to, have current mapping, whether it's FEMA maps or groundwater maps, we have to, we're subject to the state. State preempts what we could try to do. The state laws would preempt the local law in this case. So I'm not sure this is an area that would be developed in large part because a lot of it is either agricultural use, restricted, covenanted, town paid this property owner to keep it an agricultural use, and the rest of it is swampland.
I don't think it's all Connors Farm.
Okay? But even if it wasn't all Connors Farm,
That's all I'm saying, it's somebody else's property.
okay?
But Josh, you just confirmed they can develop it either way. They just don't have
But
things
is they-
like
is it-
It
junkyards.
says any structure or use permitted in the underlying zoning except for those structures or uses specifically prohibited in section 27.4, which is what those kind of
Right.
nuisance or things that we probably wouldn't.
Could you restate those again, please?
Landfills and open dumps, automobile graveyards and junkyards, landfills receiving only wastewater and/or septic residuals, including by the DEP, facilities that generate, treat, store, or dispose of hazardous waste that are subject to, and it's like hazardous waste. So without me, diving into it, I doubt very much that any of those things would even be, even you took away that this being in the groundwater protection, none of those things would be allowed from a zoning perspective anyway. While we're talking, I was just trying to look at
And I'd be a
What
little
is
bit,
this- what
just
is-
myself, I'd be a little concerned as well in terms of, I understand, I understand the point, I understand the concern, but I'm also at the same time, if there's a revised, if there's also a revised map, I think there is, it would seem to be incumbent upon us to actually, to follow that map, and if we, and I think as Jim pointed out, I think it could be, we could find ourselves being in a preempted by state law if we don't adopt the most recent map. So, I understand I understand the concern, but, so, anything further? Josh, anything further on that at all?
I was just, I was just for my, so, I was just trying to look what the zoning is, just in that corner, majority of it.
I mean, Brian should be prepared, should.
It's mostly R3. There's some civic.
Yeah, okay,
Town
so
of
right,
Amazon.
so it's the majority of that kind of triangle that would be removed as, was that Tim, is that you?
Yeah, although
Yeah.
I think, yeah.
The majority of that triangle that would be removed is zoned currently as civic space. So it's not too much development's going to be allowed. There's not many, that's limited, very limited, and then R3, which is, you could do a single-family house, but you need 30,000 square feet. And what was mentioned by, I think it was Mike, there is a significant amount of wetlands in that area of town. So even if someone was to build a house or several houses, they would need to go to Conservation Commission. I'm sure the majority of their lot or their yard would be jurisdictional. So I guess if the concern is that we take away this overlay district and, revise and update this map, that this section of town is going to receive a significant amount of development is probably not going to, is very likely not going to happen.
By virtue of the removal of.
Right, by virtue of removing this, yeah.
Okay. Okay. All right. Any further questions or comments with respect to groundwater? Okay. Josh, why don't we move on to the next,
Yep.
Next one? I believe this is the sign bylaw.
So this section is a kind of combination section. One second, I'm just trying to pull it up. Where were we? Zoning amendments. Let me just, share. So signage, so this exercise for us as staff was this is a combination of bringing the downtown, all the downtown zoning and signage, or the signage for downtown was in the planning board zoning regulations. And what we were doing was we really liked how it was set up and the different signs that were available and just the language of that. So basically we wrote the whole section, just incorporating and bringing the downtown signs to just be applicable to the entire downtown instead of just being applicable just to downtown. So the whole section is rewritten, but it's just a marriage between the current language of section 37 signage and the downtown language.
Right, so it covers everything for the entire
town.
For the entire
Instead of just, so if someone was looking for signage for just downtown, they'd be like, where is it? We can't find it. And we were just trying to put all the signage in one place. There was very minor or sort of insignificant like policy-ish changes, but basically just kind of putting it all together and having a section for signage that was comprehensive for all the zoning, just, everywhere in town.
Okay.
So.
Thanks, Josh. Any questions from members of the board with respect to the sign bylaw? Okay, any questions from members of the public? Okay, Josh, why don't we move on to the next, and I believe the final one.
Yep, so this is a brand-new section in the bylaw. We currently did not have a lighting section as we speak. We put together this new section. The impetus for this was really came out of a lot of, just several kind of complaints or just kind of concerns generally from residential when commercial lighting was kind of light pollution and just going into people's houses. And so we thought that since we're getting, a fairly decent amount of calls on this, that it's something that we should probably implement. So this is a brand new section of the bylaw. There's a section regarding residential, and there's a section regarding commercial.
Okay.
Luckily, what's nice is we do have, we have our own electric division, so we reach out to them to review it for us. We're not all experts on lumens and all the wattage and all the fun lighting lingo. So they did review it. If they had any comments or concerns, they were incorporated, but they thought this was satisfactory. We think this is something positive and something that we should be, we're promoting the dark light sky, dark sky, type of, as lighting kind of keeps moving towards LED and higher technology, and we want lights, shine down. We don't want lights shining on your abutting neighbors. So that's what we hope that this is doing. So,
Okay. Any questions from members of the board?
Nope.
No. Only question I have, Josh, just in terms of two questions. Most of the complaints, has it been downtown area?
no, I wouldn't say that. No, not in any geographic area.
Okay.
But just I would say mostly commercial shining into residential units and/or residential properties.
Okay.
But
And who would be the enforcing?
it would be the planning office or Brian as the zoning enforcement officer. Brian
So-
Sekeli, the planning
So if
director.
people have lighting complaints and such, they can reach out to the planning office.
Yeah, don't tell everyone, but yes.
Okay, very good. All right, no questions from the board. Any questions from members of the public with respect to this item? Okay. Is that, I think,
And
does
that,
anyone else on the board have any questions about these articles? We do have, just in terms of the schedule, This does, I'm looking here at the warrant, so the Finance Committee will review the warrant at 7 PM
On Thursday.
in the Toomey Hearing Room
On Thursday, yep.
on Thursday.
Yep, this upcoming Thursday.
January 16th. Okay, and so then it will, so upon the Finance Committee, then it will go, review of these matters, the whole warrant, then it will be going to the upcoming special town meeting
Yep.
on February 3rd at the high school.
Yep. I would, just in case there are any changes or modifications at FinCom, our staff recommendation is to continue this item to our next meeting,
Sure.
just in case there were any changes or modifications, so we would have the opportunity to weigh in or comment so,
So we'll continue the,
Yep.
so we'll continue the public, just before I know
Yeah.
we went through each individual one, but I asked generally about the board, if they had any further questions about it.
Do we want to move to a positive recommendation to forward to the FinCom?
I think that I don't know if we have to do that technically,
Well,
because,
reflecting what was just changed.
what was changed?
From the last time we met.
Nothing was changed.
Well, two things were changed.
Well,
So I would
Sure,
make the motion
that's fine.
that we move with a positive recommendation to forward the present amended version to the Finance Committee at their next meeting.
Okay, is motion, is this first?
Second.
Is there a second?
Second.
Mike, okay, very good. All in favor as to Jim's motion?
Aye.
Any opposed? None, so it's forwarded with our positive recommendation. So I would entertain a motion to continue the public hearing?
Make a motion to continue the public hearing to our next meeting, January 28th, 2025.
Okay.
Second.
Motion by Jean, second by Mike. Okay, all in favor, please say aye.
Aye.
Aye. Any opposed? None. Okay, very good. So let's move on to, I think, our next agenda item. We have a couple of sets of minutes. Josh, I think we have one from November the 12th, and then from November the 26th. I did make a note, just looking first of all at the first meeting minutes, very minor nit. On page 7, I think there was a reference to a vote by, a motion by Mike Spittle.
yep, I can make that change.
So this was
On the November 7th, you said November
right,
12th?
that involved, it was a motion to forward, this was the traffic report, Howard Stein Hudson for Trask Lane. It was a motion by Jean, a second by Mike Spittle, so I'm not
Okay.
sure.
Yep, so I could look into that.
His friends call him Mike.
Right, just, yeah.
Yep.
So
I will rectify that.
that sounds fine. Okay. Aside from that, I'd entertain a motion to accept.
Move to accept the meeting minutes from November 12th.
Okay. Motion by Mike. Is there a second?
Second.
Second by Jean. All in favor?
Aye.
Opposed? None. Okay, November 26th, meeting minutes. Didn't see any. I didn't see anything, but,
Move to accept the meeting minutes from November 26th, is that what you said?
yep.
26.
Second.
Okay. First by Mike, second by Jean. All in favor? Say aye.
Aye.
Aye. Opposed? None. Okay. I think that's it for our agenda. What is our, Josh, we have our next,
Yep, so our next scheduled meeting looks sort of similar to tonight, in that it's the two items that were continued. There's just the trash lane item that was discussed earlier, and the public hearing for the zoning amendments. So,
very good. Anything further by any members of the board?
Move to dissolve, adjourn.
There's a motion to adjourn by Jim. Is there a second?
Second.
Second by Mike. All in favor?
Aye.
Aye.
Any opposed? None. Have a good night, everybody.